business as an investor or a real estate agent and get more referrals and work more effectively, and most importantly, service your client better. So one key factor is better relationships with great attorneys. In every business, there's good, average, better, and best. And what I'll tell you is when you have a chance to steer your customers or refer them or encourage them to work with the best attorneys, you get the best results in every aspect of law. I think it's in every business period, but particularly in law. So we're going to talk today to really one of the great attorneys in Los Angeles who specializes in evictions as well as does probate. We'll talk about how those two relate together. So a little housekeeping before we get started. I'm Bill Gross. I'm a broker in Los Angeles, California. I build a national team of probate real estate agents. And we're also building a network of referrals. So feel free to join in. If you're watching this, we do have a podcast audience. I had no idea how big it was until my assistant and I went over a meeting today. But we do this also on video. You can join to come in live if you want to participate. Register at probateweekly.com. It's a Zoom call. And that way you can come in live and ask questions if you want to or chat there. Or if you just want to watch it on your favorite social media, that's fine. We're on YouTube. Feel free to subscribe. And that way you'll get notified when we have new content. And like the episodes you like, you'll see more of them. But otherwise, participate. We have a free Facebook group, which is Probate Experts. You can go into Facebook and join in there. And we do get petitioners, we do get attorneys, we do get vendors looking for referrals and sources of business regularly there. That's free. You're welcome to join us there as well. Local events tonight, we happen to have the best real estate event in Los Angeles area monthly is the LA County Real Estate Investors Association. It's in the Culver City area at the Iman Center, technically West Los Angeles. It's free. And at 6:30, there's a vendors expo, about 50 vendors. And then there'll be a talk at 7:30-ish with about 250 people there typically. And this week it's Bill Tan, how to structure deals. I'll be there. I'm the live podcaster there. So we'll be live streaming while we're there. So if you're there, come up and say hi. It's a free event. The best event, so even I go to monthly outside of my office that I don't sponsor myself. So it's a great event, great way to meet a lot of people and learn a lot about real estate in one fell swoop. Also, all of our these calls are on our YouTube channel. You can go to the YouTube channel, youtube.com/BillGrossEXP. All my social media is BillGrossEXP. Or you can go to episodes.probateweekly.com. If you go to the episodes.probateweekly.com, you'll see all the old episodes in one big playlist. And then in the chat box as well, I put my affiliate links if you're interested in Probate Mastery or the Earn coaching programs. Those are programs I participate in, do get some affiliate income. Feel free to join those if you're looking to do more. And then lastly, I host a program every Wednesday, getprobate.cash, which is how to use probate advances as a tool to generate more business by helping your customers get some money in advance, maybe to pay for attorney's fees or to evict a tenant or to make up back payments or such. If you do that, the additional cash is the way to help them. But more importantly, I think create the relationship with the customer where you're helping them. Feel free to learn more about that at getprobate.cash. It's a live program, Wednesday mornings, 8:30 a.m. Pacific time. We go about that in detail. Okay, I think that's our housekeeping. Oh, lastly, this is meant to be participative. So as we get going today and we start talking about things, feel free to raise your hand, put questions in the chat box. We'd love to have you participate. Also network while you're here. Put in your name, your contact info, where you do business, and then what you can do to help other people. And that way you can network with them. The idea is we should be here all generating business for each other. I'm in LA, but we can do business nationally. I've literally talked to agents, been involved in referrals this week in Port St. Lucie, Florida, near Vero Beach, in Washington, D.C. metro area, Prince George County, and in Michigan. So feel free to participate. Give us your information. Let's keep the business kind of in the family. It's funny. There's on one hand, we can look at each other as competitors, but if we all work together, we can control the business and most importantly, give a better experience to our customers. So feel free to network in there. Okay, that's the housekeeping. And I'm looking for Eileen. The Zoom link is not working. Can I resend? Oh, there you go. Okay, hold on. Here we go. 1 second here. I got my attorney on standby. Always a challenge. Technology. Who here besides me loves technology? It's always something. I'm reminded of Gilda Radner. If you ever watched Saturday Night Live back in the 80s, Gilda Radner, it's always something. It's not the Zoom link, it's the browser pop-up. If it's not the internet connection, it's something else. So forgive me for deviating off of that, but I know she's in the process of logging in. Really excited. Do I interview her before she comes on? I want her to be on when I introduce her, because I'm real proud of having this particular attorney on. This program I do every week, the goal for me is to be educational by bringing in experts in the field that we all can learn from. It's great to network with them and to get business from them, but even better than that is that if they can teach us how to be better at what we do, then the long run we'll be better off. So the idea of interviewing them is not so that you all can solicit the attorney that bring on the call, which is fine. But more than that is to realize how they do business, how they're going to share with you they want to do business, and assume other attorneys like them will do business the same way, and that will help you be more successful as you go forward in building your probate business. Okay, so as we wait for Eileen, I guess I could sing to entertain you guys. Who would like me to sing a little something just to kind of keep you guys occupied? Anybody? Raise your hands. Nobody's hands up. So we're waiting. Any questions or I know she's logging in right now. I can see it. Any questions, challenges I can help you guys with while we're waiting for our guests to get in? Any victories? I can report a couple of victories, but I don't want it to be all about me. Anybody want to share victory in their probate business? Here's the thing: you either have problems or you solve them and you have victories. That's all there is in real estate. If you don't have a problem, you have a problem, which is you're not generating enough business. So who's got a challenge I can help you with here for free? Anybody? Want to jump in? No?
I have a challenge.
Let's go.
Okay. Okay. This is, so what do you take to probate court as a realtor?
Great question.
Listing it.
Great question. And she called me earlier today, so I knew this question was coming. Ina's asking, what do you do when your probate needs court confirmation, and do you go to court? And I'm going to ask our guest to answer this as well as I bring her in. So it's changed. I'm in Los Angeles. The first thing I would say is the business is different. The law is different in every state. The practice is different in every county. And so you want to make sure that you are appropriate for your market. I happen to know Ina's going to LA County because she called me and told me that's where she's from. That's where I go. I was literally there in LA court on Tuesday on a court confirmation. What do you bring? Well, with the COVID rules now, the truth is you don't have to go. You only have to go if you want to do a good job and stand out from the competition. And so what I would say is I go not just to service the client, I also go as a marketing opportunity. So the hearing is 8:30. I'm there at 8 o'clock. I'm there good looking and charming, dressed, ready to go, dressed professionally at 8 o'clock so that anybody who's there a chance to service. On a court confirmation as a listing agent, the attorney or the estate's obligated to look for anybody who might be there to bid on the property. And so I stand in the courtroom outside the courtroom and ask who here is regarding 123 Main Street, trying to find that last minute bidder might come up, and they have to be pre-qualified. What do you have to do to be pre-qualified? You have to a cashier's check in the amount of 10% of the minimum overbid. It has to be made out to the estate. So you should have with you the name of the estate and the dollar amount of the check. I just type it out on a piece of paper. So I show that to them, make sure that's what it is. If it's that, we're good. If it's not that, we're not good. Now, the attorney may want to take the lead on that. You need to work it out with the attorney. Sometimes they aren't there, and so it's left to you. Sometimes they are there and they want to control it. So there's only one quarterback on a team. Make sure you and the attorney work out who that quarterback is. But I would be there. And so many realtors say, I can't meet the attorneys because they're not in their office. There's your chance. Hopefully they're there in court. Not to mention you get a chance to see the process, see the judge, see how things go. So I'll introduce you in just a second, but Eileen, the question on the table is, listing agent has representing an estate that has a court confirmation sale tomorrow. What, if anything, do you expect the listing agent to bring to support the estate in the process of getting the court to confirm the sale, or anything? Oh, she's muted. Oh, she is.
Well, I'm not, and I apologize because is this just a regular court confirmation sale?
Yeah. So regular probate court, limited authority, court has to confirm the sale. You have a buyer. We don't know if there's any overbidders or not. Do you expect the listing agent to show up? tell them to show up? Do you get involved in that process at all? How do you, or do you get involved in that at all? What's your feeling as far as the real estate agent showing up on
Well,
that?
in honesty, I haven't done a probate confirmation in probably 15 years because
There you go.
my focus is, landlord tenant and, dealing with quiet title type actions. For instance, I have an estate that is trying to sell a property right now that is found that chain of title in 1964 is bad. And had to cancel the sale and having to file a quiet title to fix it because they didn't have the right to transfer it to a trust the way they did. But I don't know much about probate confirmation hearings.
Okay. Well, I'm just curious what you would think. I mean, knowing that you don't experience that, but you're an attorney, and just kind of get your take, if you happen to have one, or if you just happen to be there, what would you think of a real estate agent showing up, dressed professional, offering to be of assistance? Would that be something you go, wow, at least they're doing their best to help out here? Or would you rather not be there and let them just handle the business on their own?
No, I don't mind if they're there as long as they don't try to interfere and speak up when they shouldn't. I don't mind if anybody is there. Anybody can be in the audience for any particular reason as long as they don't try to speak up or interfere in the court proceeding.
Right. As a general rule, I think you would agree, the attorneys really are in control of the process for the state. And so you really have to be in a supportive role. There's one, I would say there's one quarterback on the team. You've got to do, the quarterback calls the plays, you have to run that play. Does that sound fair?
Yeah.
So let me just introduce you properly here. I'm sorry I had a little problem there with the connection on the Zoom link. I'm really excited to have Eileen Kendall from Kendall Law in the Los Angeles area. And it's interesting because I've actually dealt with her firm on two different cases from two different angles. One was, for me, a probate case where there are two clients, two pieces of probate, and there was a little disagreement as to selling or not selling, and she represented one of my two clients. And then I had another case where an attorney refers me a property they're going to sell. They need to evict the tenant, a commercial property. He speaks really highly of the attorney and of the firm as being the experts in eviction. And I thought, well, who's that? And he told me Kendall Law. And I thought, well, that's interesting. I had this other case with them. And when I called the office and talked to the staff, they were like on their game on evictions. They knew exactly what they're doing. I hadn't really dealt with them in that capacity at all. And so I came to find out that they really are. And I had a very nice chance to talk to Eileen, interviewed for my YouTube channel, but really one of the experts of evictions here in LA County, Eileen Kendall, Kendall Law. Eileen, thank you so much for coming to our show today.
Oh, you're welcome.
Just a little brief background. Where'd you grow up, and then how'd you get into law?
So I am originally from back east. I'm from Buffalo, New York, but we moved out here in the 4th grade. How I got into law is I'm not really sure. As far as back as I can remember, in middle school and probably even younger, I had visions of being a lawyer. Those visions changed over time. For some time, I thought I wanted to be a corporate lawyer because I wanted to be on top of Capitol Records building. I don't know why I thought that that's where attorneys would be, but wanted to do business. So I took Japanese in high school, and then I ended up in real estate in law school. I worked for a firm in Washington. I went to school at Gonzaga in Spokane, Washington. And I just started working for a firm there that did real estate. And then that's what I fell into when I got back to California after graduating. And that's what I've now done for nearly 20 years.
And in particular, I know you do a lot of work or specialize in evictions. Tell me, how'd you end up in that piece of the business?
Yeah, when I went out on my own 6 years ago, it was the thing that was easy to market. People understand that and they need it. I didn't know it would be such a popular niche. Like I said, you go to BNIs and you go to different marketing things, and the thing that people understand is needing to evict a bad tenant. And so over time, it just grew, and now it's got to be at least 75% of my business. We have 6 to 10 different property management clients, as well as we represent a lot of individuals. I represent a lot of fiduciaries, somebody that steps into an estate because the family can't handle it or there's something going on. And so, yeah, it's a primary part of my business now.
And I have to tell you, in my experience as a real estate agent, when customers pick in a firm to do an eviction, in my experience, 90% are dissatisfied because they pick more of a plain vanilla paper mill type eviction service and find out they need, really legal consultation, legal representation, legal authority. Your business is a little more than just, I'm sure you do fill out the standard paperwork. I know you do because you did when I was involved with, but I also know that you do the litigation and do the more involved process. How do you kind of take on that angle or that approach to your business?
Yeah, and what they're called mills. They're about volume. When you're about volume, we're legal services with a personal touch. We're about our client being a client, as a person, not a number. And so we deal with each on an individual basis. And it's usually always somebody in our team. And when things get complicated, because I have an extensive
this is Sandra.
background of litigation, I can handle those things fairly easy. Like we're set to go to 2 jury trials on Monday in cases where a lot of the mill attorneys just keep pushing the envelope and asking for continuance and trying to settle instead of taking it head on, and tackling the issue and just pushing it and being aggressive.
Yeah, that's the thing that I think customers most complain about is, they took my money, they filed the paper, now it's a problem, and they hand it back to me and say, good luck. And I think that's where you guys kind of step in and take over. Now,
or it gets too complicated that they just don't want to do it.
So I know that in probate, there's a different legal status than tenant for somebody who comes into the property, maybe with permission of the decedent, maybe their boyfriend, girlfriend, whatever. They're not a tenant, they're not entitled to the same protections, but they still have certain legal rights. Can you talk a little bit about evicting? And they might be an heir, might be a son of the decedent as well. Can you talk a little bit about the difference of that kind of eviction than, say, a tenant who's paying rent and then they want to get moved out for some reason?
Yeah, so typically what that's going to be in the situations that we have seen, especially like in a caregiver situation, a girlfriend care, situation, when the decedent dies, is that person's what we call an at-will tenant. Basically, there is no rental agreement. There's no agreement for a specific amount of time or about a money. You're basically a guest at the invitation of whomever was there before. And the way that you terminate those is 30 days notice of the death of the person, because we get it even where it's a rental unit, the mother is on the lease, somebody's staying there, so it's the death of a tenant, and then your termination of the at-will tenancy. And we treat it similarly if it's the owner of the property that is needing to do that. And we've been very successful in those. Typically, we don't even have to go to trial in those. We file a motion with the court just showing what the facts are. They can never prove that they've paid rent. They never can prove that they have some kind of agreement to have a more I don't want to say legitimate, a more traditional landlord-tenant relationship, but sometimes you have to be creative. And, when somebody calls on that, I ask those questions. Are you sure you never took rent, or the decedent never took rent? Because then you have to consider, did they make like mortgage payments or anything like that? But yeah, we call it in the legal world, it's called an at-will tenancy, and they're entitled to 30 days notice, and then you still have to go through the eviction process if they don't leave.
And then there's a different status if that at-will tenant is also an heir. Maybe they're a son, a grandson.
No, because typically in that situation, the ones that I've seen is that asset is the only asset. That asset has to be sold for the distribution. The trustee has the right to dispose of that asset. They're still an at-will tenant. Unfortunately, sometimes I've even had to do it where it's a special needs trust and the person that we're terminating is a special needs. But unfortunately, he's, high on crack and burning up the house in the microwave, so there are certain situations, but it's treated the same way.
And so typically, even with the COVID restrictions that are in place currently or trailing on still, do you practice in Los Angeles? Are you able to get those kind of at-will out within 30 days?
Mm-hmm.
Yeah.
Yes.
And then in the case of an heir, do the legal fees come out of that heir's distribution?
I have no idea how they work that out. I'm paid up front. I'm paid hourly. How they arrange for that, I don't know.
Got it. I've seen that. I've seen cases where the judge almost routinely, it seems like the judge will award that assessment or that adjustment to the distribution because in essence they spent those monies and those. So again, you're just involved in the eviction piece of it. It might be a probate, but you turn that back over to the probate attorney to take it over from there.
Oh yeah, I don't have anything to do with the trust or the estate the proceedings.
Got it. Great. Hey, look, guys, I am able to talk to her. She's fantastic, and she's agreed to be here for an hour. I can talk all day, but this is meant to be participant. This is your chance to learn about how eviction works, how working with an attorney works. So if you have questions, feel free to raise your hand in the reactions in the Zoom or put a question in the chat box. I'm glad to pick it up there. And then if you're watching on YouTube or Facebook as well, feel free. Just real quick on Facebook. Couple people checking in. I see Steve, thank you. Matt Driscoll also thank you. Bob asked, should an executive trust have a role to play with health issues that relate to typical living issues versus day-to-day medical decisions? So Bob asked a question. So you don't really get involved in trust administration cases. Yeah. So Bob, that's a little out of her range. The question is, should an executive trust have a role to play with health issues that relate to typical not live or die issues versus day-to-day medical issues that children would make up with their moms? And so the answer to that is really more for a trust attorney. It's going to vary by state. The key thing to remember is laws vary by state and procedures vary by county. So it depends what state you're in. And I would talk to a trust attorney on that. And we'll have one next week, but this week we're talking about eviction. So we're lucky to have her on that topic. Okay, so I think I'm up to date on questions there. So what's the, currently, is there a time issue as far as filing an eviction? Can you give us kind of like the standard timeline? You have an at-will tenant. Is it filing and then they get noticed 30 days? Is there a hearing that has to happen? What's the timeline look like?
You have to do the notice of termination first. So if you want to just go with a timeline of an at-will tenancy, it is a 30-day notice of death of the occupant or the owner, and 30-day notice of termination of at-will tenancy. And then you have to wait the 30 days. On the 31st day, if that person doesn't move out, you can then file what's called the eviction complaint, the unlawful detainer complaint. The timeline for that really then it varies on very different things. So once it's filed, because you have to wait for the court to file. So it could be 1 day, it could be 5 days, depending on how busy the court is. Once it's filed, you have to then serve it. If you can personally serve, so if you're the named defendant, Bill, and I personally serve you, a response is due in 5 days. But if Bill's not available and I serve Martin instead, it is 10 calendar days for service to be effective, and then it's 5 court days for her to answer. So it is, you're waiting essentially 15, 17 days, depending on when it was served. From there, as I tell people that call in consultations, it then really depends on what the tenant does next. Everything is dependent on the tenant. If there's no response at that period from the 5 or the 15-ish days, you can do a request for entry of default and default judgment. Depending on how fast or slow the court is, that can be 1 to 5 days. Once you have judgment, then you get a writ. Again, can take a couple of days for the court to issue that, and then you send it off to the sheriff. Some sheriffs are quick, some are super slow. So if you're going by way of what's called a default, you're usually anywhere between 22 to 30 days. Then the tenant, instead of going default, can answer, and they can answer representing themselves and request a court trial. Then you're looking at about 40 days to the point that you get a trial. And that's from the time the complaint is. So from the time the complaint is filed to trial, you're looking at 40 days. Now, if a tenant gets an attorney and makes a jury demand, you're looking anywhere from 4 to 6 months. Maybe more, maybe less. It really depends on how busy the court is, what settlement communications are, what their defenses are. It really is an unfortunately pretty dependent on what the tenant does.
And so if a tenant, even when, let's say, an at-will insists on extending the process with every possible legal right, they're going to demand a court trial, they're going to get an attorney and such, you're still talking 6 months, 9 months to get them out, it sounds like.
Yeah.
Yeah, there's no shortcut process. But that's
Well, that's short. That's short compared to going to regular civil court, but it really depends. Our goal is to get things to trial within 60 days.
okay. And then obviously an alternative would be at some point to make some sort of settlement, because it's costing your client money and it's costing the tenant potentially the risk of losing the court case. Do you get involved in negotiation of cash for keys? Is that part of your process?
Yes.
And so do you have any idea, or are you able to share like what percentage of the time that you start that process do you end up settling versus what percentage you go to court?
Well, typically, if you're talking about an eviction proceeding, the settlements are less than a cash for keys than what's called a stipulated judgment. So if we file litigation, I would say 98% of our cases settle without trials, and they go into what's called stipulated judgments. And that is usually not even cash for keys. Usually it's a waiver of rent or an extension of time to move out. Typically, the cash for keys is recommended to be negotiated prior to even starting any type of termination proceeding. So if like you're in Los Angeles City and you have something that is going to be tricky, like I had a potential client call today thinking about buying a duplex in Culver City. The tenant is over 62, has been there 15 to 20 years. Unfortunately, you're never going to be able to terminate that tenancy. So if you are thinking about buying it, the best option would be to negotiate some type of cash for keys to get them out. But good luck. When you have somebody that has been in their home that long, it's really hard. But the cash for keys is certainly, I always recommend the owner to try to negotiate that without an attorney, because once an attorney becomes involved, they think it's hostile and they want to go get their own attorney, and then they go get some tenant protection attorney that's going to jack it up and make it very unreasonable. So if there is some kind of ongoing relationship with the tenant and the owner, I highly recommend that the owner have these conversations on a very nice, friendly level. Look, I'm trying to sell, or I want to do an owner occupancy or whatever it is. What can we do to work this out?
Do you, but behind the scenes, you're advising your client as far as the paperwork and the process still?
Yes.
Okay. And so at the end, if they come to some agreement, I would imagine you're helping them formulate some sort of a written agreement that they would then take and sign in exchange for a check or something like that.
Correct.
Do you have can you share like a range of what you see as cash for keys? Because I interviewed, I don't know if you're David Bornstein, he's from San Francisco, and he's an eviction attorney specialist. And he was talking about some pretty big numbers. I've seen buyers offer, I've never seen tenants accept $40,000, $50,000. I've seen real estate where it made sense if we could get them to take $50,000, and buyers or prospects are shocked when they say, well, we'll offer them $50,000. And I would say the tenants already declined that number. Am I using some old numbers? Are there hard numbers that you see tenants accepting and closing deals on, or what do you see as a range?
So I can see some of the questions. I want everybody to know that I am not licensed in any other state than California. I practice in Southern California, mostly in Los Angeles County. So anything I'm talking about doesn't go beyond California, and specifically in the county, because I do see some people saying like Georgia and Seattle. I have no idea. I cannot advise on anything outside of California. In the city of LA, there is dollar amount set for properties that what are called rent stabilized properties. And in that instance, it ranges from about $8,800 if you're a mom and pop for owner occupancy to about 20 or 30,000 that is required as relocation. However, I've negotiated cash for keys for much less, between like 5 and 10. But I've had instances where, tenants have, kicked 30 to 40 out, and say, I'm not even interested. Right. But I would say that the typical range is somewhere between that 8,800 and the 30,000.
But that number for the RSO is not guaranteed to a new buyer, meaning just because they want to relocate and are willing to pay that maximum amount doesn't mean they get the tenant to agree to that, correct? The
Yeah,
tenant's-
I mean, the tenant can refuse.
Right, and then you're stuck, and there's really no way to force them out in those circumstances.
Correct.
Yeah. And for those listening, I do want to say, we also interview attorneys from other states. And the idea is the principles here are similar in most states. California is more regulated, more probably tenant friendly than any other state or most any other state. But my goal here for those of you who are not from local, and also her practice is local in certain cities where the laws, you have state laws in California, you have county regulations, and then you have individual city laws as well. And it varies by city. But even those of us not in those cities, the principles are similar. And what I hear you say here is how on the ball she is on the details versus some of the attorneys who don't do eviction all day long, don't have those answers at their fingertips. That's what you're looking for when you introduce your client to the eviction specialist in your county or your state as well. So thanks for identifying that, Eileen. And of course, I'll say for Eileen's benefit, and she's not giving any of us legal advice, she's just giving us an overview of the business matter of the eviction business. Let's talk a little bit, if we could, Eileen, about kind of the small business hat you wear. In addition to being an attorney, you run a business, you got to generate business, you have payroll and things like that. How much time do you spend? How do you manage or balance your time between Eileen, the attorney practicing law, and Eileen, the business owner running Kendall Law?
Not enough. So I opened my practice 6 years ago in October, and up until the pandemic, it was just me. I was working out of my home office. I had, small potato type goals, but luckily or unluckily, I don't know what you want to call it at this point, because I'm pretty exhausted, is that my business grew organically. I love to speak with realtors. I go and do our local association. I do presentations. And the referrals just kept coming in. The pandemic hit, and at first I thought, oh crap, what's going to happen? You have all these landlord tenant things. And that's at that time was more of my practice than I wanted it to be for just me, because I really love litigation. And I hired my first employee. We have 8 now. There's 8 employees with in the last year, the majority of them. And it has been a big struggle. I have a business coach that says that I should only be billing about 75 hours a month towards client work, when I usually bill 120 to 140. And then the other part of that should be devoted to the business. Unfortunately, I am squeezing in the business when I can, because I'm the one that has the consults, and I'm the one that, I have to oversee the legal work. And like I said, I start a jury trial on Monday because the client, hired me and not my associate, and didn't want an associate to go do it. So the other issue is managing expectations that, there's a team and it's not going to always be me. And I do need to devote more time to the business side, but fortunately it's growing organically and I don't have to do much, and it's about having the right people. So I have a business coach, I have a bookkeeper, I have a good CPA, I have, all of the people in place that can help me try to run all of these different things. And the person I hired first, she's gone through many hats, and she's now taking on the hat of COO. Like, she's really learning everything so that she can be the go-between.
Nice. I know the first matter I did with your firm, I never did talk to you, and it was all handled. And I'm not saying that to complain. I'm saying, I had your name as attorney, and I called in and I got routed to one of your associates and your administrator, and between the two of them, and really more the admin person, was really good. And so everything got done. I'm copying the attorney to be, polite. But the reality is the admin, if you have good staff, then you can delegate more and more. And I'm sure you're learning your way through that process. Well, good for you. Okay, back on point, we have a question from Joan. She's in Riverside, but she has a client who has a property in Carson, pretty close to your office, I guess. Tenant's been there 20 years, pays $1,200 a month in a duplex, with the landlord need to pay the $8,000 to $30,000 to each tenant to evict them to sell. Just to clarify one point she made, Eileen was quoting the rent stabilization ordinance in the city of Los Angeles, which is one city. There's other cities, Carson being another city. So on a case, Eileen, in Carson, are you up to date on the details there? And if you have somebody paying below market?
typically I would verify the address, because even like in Lomita, there are some parts of Lomita or some parts of Torrance that can still fall in with the city. But let's just say that it is a Carson property. I think she said I heard you say it's a duplex. Typically something in Carson would not have their own rent stabilization ordinance. They are just subject to the state, because the state law in 2019 changed to enact the Tenant Protection Act. So any property that is 2 or more units, there's an exception where, unless it's a duplex where owner occupied at the time that the second unit was leased, but let's just say that it's 2 tenants, they've been there a long time, it is not. So let me say is that right now we're still in the Los Angeles County eviction moratorium, so you can't do anything, but that is going away come January 1st. So let's just say you're in 2023. You have to have cause. So you cannot terminate without cause. So you have to have a breach of lease, an owner occupied, something that's in the code that allows you to do so. You can still do a cash for keys, but the relocation under what we call AB 1482, the Tenant Protection Act, is 1 month's rent. It's nothing like the city of LA that's 8,800 to 30. If you had grounds to terminate, all you'd have to do is waive 1 month's rent or pay 1 month's rent within 15 days of the notice. So your negotiating dollar amount is probably much less. But if they've been there a long time, it usually takes quite a big amount. And I mean, it doesn't necessarily, but if they've been there a long time, there hasn't been rent adjustments, they're under market. A lot of times the problem is that the sticker shock for people to try to find something comparable. So you have to consider that when trying to help them, or not help them, but to compensate them so that they can go get something new.
Yeah, that's a big part of it. Is this lady paying $200 a month? Even if you get her out before she moves, she's going to look around and find out she can't find something comparable for less than $2,000. That's why they want her out. Well, she may not have that extra $800 a month. And so now you have a case where she's faced with being homeless. She's going to fight like her life depends on it, because it might to some regards, or it might feel like that to her. So you have to kind of look at it from their side to at least understand how they're going to react, I think, to be realistic. So you bring up a good point with the county scheduled to be terminated December 31st or January 1st. We never know if they'll extend it or not, right? Last time, kind of last minute, they extended it. What's your assumption on the backlog? I mean, we haven't had evictions now allowed for so long. Do you see?
That's a misnomer though, Bill. We've been doing them. Last month in the eviction moratorium, we had 30 files. Even this month alone, I think we've regained possession in, gosh, I had a note because I wanted to do more wins for this month. I think we got possession in 6 different properties. There is a backlog, yes. The backlog seems to be more on tenants' attorneys having too many cases that they can't do their jury trials when they're sent out. The other backlog is sheriffs. The cases are being processed just as they were prior to COVID. Now, maybe in a month or two, it might be a little more backlog, but we have been full steam ahead the last 2 years.
That's good to hear.
I mean, there was maybe a 6-month period of time where it was slow because they weren't issuing summons,
Right.
but then the law changed. I'll tell you, I think it's changed 15 times in 2 years.
Which keeps you busy.
Yes.
And should, I think owners don't realize how complicated and detailed these things are. And, the attorney's job is to keep up on all those details. So kind of hard to do. Okay, so there's that. Yeah, and so I think, again, you need to understand what's the solution for that person out the door. One of the vendors, I'm going after this call, there's a local real estate event where there's a vendor who is a owner, landlord representative. He's like a private investigator, and they will find a case where you have a tenant who's paying below market and discover there's 4 people living there in violation of the tenant. And we'll discover they have pets. We'll discover they're doing criminal activity and such. Is that part of the process of eviction? Is that something you can talk about?
Yeah, I mean, we have a lot of that. And that was a lot of what was getting through, because obviously you couldn't do non-payment of rent. And then there was some circumstances where you couldn't do an unauthorized pet or occupant as long as it had to do with COVID in the city. But we have done so many, and jokingly say I could write or put together a coffee book of the horrors of tenants. But nuisance and criminal activity are the top things that, you know, are I don't want to say easier to prosecute, but those are the ones that are easier to get through because the facts are there. We file motions on, you know, the evidence. We had one in the two that stand out in the height of COVID. One was a city of LA property where the people were stealing from the neighbors' yards and piling the stuff up in the common area. You know, the hoarding just in general from other stuff. And I mean, we had 5 or 6 declarations from neighbors about how horrible these tenants were. And we were able to get them out on a nuisance. And then another one was a guy, he had a hoarding situation too, but then it got worse when he went out gambling one night into some establishment to bring a lady back, got high on coke, and then there's a knife fight and police coming. So those are like I said, I don't want to use the word easy to prosecute, but there's little defense to that.
That's all wrong to do all that stuff, right? Just
checking. Yes, it's all bad. That's why you get them out. But what I mean is that, you know, when you have a non-payment of rent, they can claim all these habitability issues or these other technicalities where there's very little defense to these other ones.
One of the things I always tell my clients to talk to their attorney about when you're renting property is exercising your rights to inspect the property from time to time, so you can either prevent those things from happening or discover those opportunities. You know, many times leases offer the landlord the opportunity to do an annual inspection. They have to give a notice or whatever it is. And you do the inspection, you discover, oh, there's 5 people living here, and the lease clearly says, you know, nobody else allowed or whatever the rules are. How do you advise owners or buyers of, you know, rental property? What do you advise them to do as far as their rights to do such inspections, if any, you know, on a regular basis to prevent these problems? Or do you?
Yeah, so a lot of times, unfortunately, people come to me after they close. It's better to have those conversations before you buy, like the call I had today where their agent gave them my information before they decide to, you know, remove contingencies. Because unfortunately, a lot of people don't get all of the right information and then learn that they're stuck later. But definitely, if you have a property after close of escrow, you definitely want to have that inspection. You want to make sure that you have all the documents. And I highly recommend that you don't just do, you know, here's, you know, I'm the new owner and here's where you send all the information, is do a new lease. Do a lease with you, getting all of the information for all of the people that are in there. Because a lot of times you get these purchases and the tenant's been in there 10, 15 years. The children are now adults and living there, and that causes problems down the line of how do I get these people out, especially if you're taking rent from an adult child and they're not on the lease. You've now created a month-to-month tenancy. So you definitely want to do an inspection when you get it. You want to do yearly inspections under the lease. You want to try to get a new lease signed, especially if you don't have anything that's really concrete and is super old. And do your yearly rent increases. I get so many people that come to me from inheriting property that, you know, we're so under market. What can I do? And unfortunately, most jurisdictions now in California, you can't do much. You can only raise it a little bit. And and I fell victim of that. You know, you don't want to raise the rent because you have a good paying tenant, but 5, 6, 7 years down the road, you're kind of in trouble because now there's nothing you can do. So you need to at least raise the rent a little bit every year and make sure that you have everything documented. I find that so many clients come to me and they don't have a good file. They don't have a good communication file, that they're doing things just kind of willy-nilly. And it just makes it very, very hard to prosecute those cases.
Yeah. Okay. Dave asked an interesting question. As a tenant whose son moved home from prison,
yes,
there's a clue. During COVID, the son's a gangster. that's a loaded term, terrorizing other tenants. I guess that's what they do. Lost 2 good tenants as a result, can we evict? So
So the
hard to-
question is maybe, with cases like that, the biggest question I have is do you have witnesses that will be willing to testify to that? You cannot win one of those cases if you don't have anybody but the landlord to testify. We've actually even had a judge tell us that because our witnesses were scared and didn't want to testify. And the judge says, then you'll want to continue this trial and not go because I will not grant this for you if all you have is the landlord. So we had to convince the tenants to come forward. Yes, you can evict, but to do so, you need to make sure that you have, and especially if it's, it doesn't say if it is or not, but if it's a city of LA, your notices have to very specifically say date, what it is and the witness of it so that they know exactly what's going, and who saw it and who witnessed it and when it happened. So you definitely have to have all of your ducks in a row to be able to win one of those.
Also, I would say one of the opportunities would be to call, if there's police reports,
That's
it says
important
terrorizing neighbors, theoretically, terrorizing neighbors causes police to come, and there's police reports will identify who the perpetrators of these problems are. They may not be worthy of arresting them, but a couple reports will show a pattern there that will help the process, correct?
Yeah, absolutely. I've actually had a judge right when COVID started. I had an incident where one tenant threatened to kill and bury the other tenant. And we were going in to try to get the summons issued because at the time you could only get a summons in those cases if you had a health and safety issue. And so I went into court to present this safety issue, and the judge asked, is there a restraining order or a police report? And I said, not that I am aware of. Then it must not be that much of a health and safety issue if they didn't feel like they needed to call the police.
Right.
So if there is threats, if there is complaints, even noise complaints, any type of record of police report, or if it is enough to the level of a TRO, a restraining order, then that's what needs to be done.
And I know I work with the police. I'm on a neighborhood council here in Los Angeles, and the police constantly say you need to call us so we can create a record of multiple visits. And they start building a record. They can build a case and they can investigate. Absent that, there's not much they can do. And they'll say, citizens will say, well, he's been a criminal for this long, but if there's no record of police calls, it's difficult to make that case. So Ahmad asked another question, kind of similar. In Inglewood, he has an 8-unit building for sale. And there's a lot of these. There's a couple of tenants that got COVID rent subsidies. They've not been paying rent since March 2002. Can they be evicted? Will that be cash for keys? So he's asking, now Inglewood's another one of those where there's the city of Inglewood and there's Inglewood mailing address in the city of Los Angeles. So I'm not sure if you get into the particulars of Inglewood, but for non-payment of rent, people got subsidies. There's like a whole host of various rules and regulations and
typically
changes.
typically that was from Housing is Key. And so again, Inglewood does have their own rules, but they are incorporated, if I remember correctly, and then they would be under the county. And so what the county is basically saying is the way that it reads, and they just on November 15th, for those in the California area or in even Los Angeles, there was an injunction issued a couple months ago by the district court saying that the LA County moratorium was ambiguous and vague. And on November 15th, they voted those changes that specifically outlined what being affected by COVID-19, what financial distress means. And really, while I have hated every single one that has come in, changes, it annoys me. These were good changes. These are changes that really outline it better for people. But basically, there's a period of time that was, and I just can't remember. There's a period of time, I think in middle of the year this year, that the county rules were preempted by the state law. But basically after June 30th, so anything after July 1st, we're prosecuting non-payment of rent. They can assert an affirmative defense in any unlawful detainer eviction that they are protected. but it is their burden to prove that they have suffered that financial distress, and it's outlined now very specifically in the resolution, and that they can't pay the rent because of that. And it has to be because of COVID, not because I just don't want to pay the rent or whatever other reason there is. So that burden is really strong on the tenant side. So I'm prosecuting those and we're winning those. They don't have, and most of them can't. And then also in that time period, some of those protections, or a lot of those protections, you have to fall in that 80% below median income, household income. So if you have 2 or 3 people and you make enough money that you fall above that 80%, you're not protected. So from July on, we've been moving them. I do not recommend going for earlier because of all of the different time periods and the restrictions and this and that. Take them to small claims, go get the money through small claims. But for possession, if they're still not paying rent, we're doing it.
And how many properties did you get back last month?
I want to say that we got 6.
I love these statistics. I love, and that's just your firm. And I'm not making it sound like you're small, but you're one firm, and it's just exciting to see when people say can't be done, it's being done. And if you need help, one person you might want to call is Eileen. We're kind of up against the hour, and you've been very generous with your time, Eileen. So I just want to thank you. For people who are interested, for real estate agents who have business to bring to you, or owners or whatever, or maybe attorneys who do other practices besides evictions, the best way to get in touch with you would be at the Kendall Law website, KENDALL law.net website.
Yes, and we do have, we're on all social media platforms. So a lot of these changes that are happening, I post on social media. So you can follow me there. We also have an info@kendallaw.net. It's 3 L's, KENDALLAW.net. And you can send emails there, and my staff will funnel you to the right person. If it's something about setting a consultation, we have an intake specialist that can reach out and move forward that way.
And you do. And like I said, I got involved in a case where I'm working with you and called for you and got properly appointed to the right associate and then the right admin person, and your staff was on the game, and we all got paid. It all worked out. Everybody's happy. So again, I can recommend you wholeheartedly. And one of the best attorneys I've ever worked with as one who brought me back to you as far as the eviction business. So just really honored to have you today as a guest. I appreciate the time you spent sharing with us. I appreciate your education. And thank you so much, Eileen. I appreciate
You're welcome.
having you.
Everybody have a happy holiday.
Thanks. And for the rest of you, just a couple quick housekeeping announcements. Again, if you happen to be in LA tonight, the LAREIC is in Culver City. That's going to start at 6:30, so about an hour and a half. I'm going to be there live casting. Come and say hi if you're there. It's a free event at the Iman Center. That's LAREIC.com. That's every second Thursday of the month here in Los Angeles. Feel free to check that out. And then in the chat box and in the description of the program, I'll re-put in key resources. If you're looking to build your real estate business, whether it be you're looking for some live streams to come to learn more education like this, you want to see the past episodes. We do Probate Weekly every Thursday, 4 p.m. Pacific time, 7 p.m. Eastern. You can register at Probate Weekly to come in live and ask questions. You can see the past episodes at episodes.probateweekly.com or my YouTube channel. All the programs are streamed there. I'm Bill Gross. I'm the LAProbateExpert.com. Feel free to reach out on social media. I'm Bill Gross EXP. And again, we do this every Thursday, 4 p.m. Thank you to all those who asked questions, Ahmad and all the others. I appreciate you. And again, a shout out to Eileen. She's fantastic. And thank her for being here. Have a great week, you guys. We'll see you next week.